Welcome back to Legal Threads, the podcast where we untangle the knots of civil procedure and tort law to see how the law really works in practice. I'm your host, Chat, and today we're digging into a case that shows how federal courts deal with bad faith removal tactics, Keller Logistics Group versus Navistar. Here's the setup. Keller Logistics, along with two related trucking companies, sued Navistar, the truck manufacturer, in Ohio State Court back in 2016. The plaintiffs claimed that 65 Navistar trucks they purchased broke down soon after delivery. They named Navistar, which is incorporated in Delaware with its principal place of business in Illinois, and they also named a local Ohio dealer, Defiance Truck Sales. Because the plaintiffs were from Ohio and the dealer was also from Ohio, the case wasn't removable. There was no complete diversity. For more than 2 years, the case worked its way through state court. There was a motion for judgment on the pleadings, a mountain of discovery, and eventually a pending motion for summary judgment. Then in March 2019, right as the summary judgment motion was being fought, the plaintiffs voluntarily dismissed the Ohio dealer. That left Navistar as the only defendant. Within 30 days, Navistar removed the case to federal court on diversity grounds. So what's the problem? Section 1446, the removal statute, has a 1-year limit for diversity-based removals. If more than a year has passed since the case began, you generally can't remove. Here, the case was 3 years old by the time Navistar tried. Plaintiffs moved to remand, pointing to that 1-year bar. But the statute has an exception. If the plaintiff has acted in bad faith to prevent removal, the 1-year limit doesn't apply. And this is where things get interesting. Navistar argued, and the court agreed, that Keller had joined the Ohio dealer purely to block removal. The evidence was damning. Before the suit was even filed, Keller admitted at a meeting with the dealer that he had no problem with them, but his lawyer advised naming the dealer to keep the case in Ohio. During litigation, plaintiffs barely touched the dealer. They issued nearly 300 discovery requests to Navistar but only a few dozen to the dealer, and most of those were really aimed at Navistar's conduct. They never deposed dealer employees. In their 100-page brief opposing summary judgment, the dealer was almost never mentioned. They never even tried to settle with the dealer. And when pressed in court, plaintiffs' counsel couldn't explain what facts against the dealer they thought they had at the start that they no longer had by the time they dismissed. All of that convinced the judge that the dealer was just along for the ride, a jurisdictional shield, not a real target. The court held that plaintiffs had acted in bad faith to prevent removal. As a result, the 1-year limit didn't apply. The motion to remand was denied, and the case stayed in federal court. So what's the lesson? Keller Logistics shows that federal courts will look past appearances when plaintiffs use local defendants as pawns to block removal. If the evidence shows that the non-diverse defendant was never seriously pursued, courts can find bad faith and allow removal even years after the case began. It also raises ethical questions. Rule 11 requires lawyers to certify that claims are brought for proper purposes and have evidentiary support. Naming a defendant solely to block removal, without intent to pursue them, risks sanctions. And advocacy in hearings that evades these realities can cross the same line. At the end of the day, Keller Logistics is a cautionary tale. Plaintiffs can't game the system by keeping a sham defendant in the case. Federal courts will call that bluff. That's it for today's episode of Legal Threads. I'm Chat, and thanks for listening. Join me next time when we pull another thread from the fabric of American law.